TV.
For sharing the country morning at NTV with me, Wameli. We are getting into the most contentious conversation of the day. NUP withdrawing their election petition. That was yesterday when Robert Chagulanyi decided it was time to withdraw the case. Why? He gave some three reasons. He said the three justices should have recused themselves. Supreme Court Justice, that is Alphonse Owenyi-Dolo, the DPP, former DPP, Mike Chibita, and also Muhanguzi Ezekiel, who is related or a brother to the Security Minister, Eli Tumwine. Also, the detention and arrest of several NUP supporters, several polling agents, several election observers, and also those are some of the issues that they mentioned as to why they're advocating. Also, the limited time that they were given to adduce information within the Supreme Court. Failure of the court to allow additional information or evidence, which was allowed in 2001, 2006, and 2016 during the Amama Mbabazi Museveni petition. But I do have Anthony Wameli, the head of the NUP legal team. He's not alone. He's joined by Rwakakamba, the executive director for the Agency for Transformation. Both gentlemen join me right now. Very good morning, Anthony and Morrison. All right, let me start with you, Anthony Wameli. Let's talk about why Robert Chagulanyi decided to pull out this case.
He doesn't see justice. You see, justice is not delivery. Justice is a process, and just to be seen at every stage as one progresses to the decision. So if from step one you don't see signs of justice, you see signs of bias, lack of independence, impartiality, then you choose not to wait for the final fate. So, and that point is where he says, no, I would rather withdraw my case than to see me taken to the slaughterhouse.
Did Robert Chagulanyi have this information initially, even before going to the Supreme Court? It seems like everyone was telling him the same, that these are cadre judges. You'll not get any victory that you're looking for because President Museveni's victory has not been overturned based on the history that we've seen. 2001, 6, 2011, no, 2011 there was no petition, but 2016, it was never overturned. Didn't he have this information before going to the Supreme Court?
You see, we want to court for two reasons. One, to give these particular judges a chance to exonerate themselves. Exactly. Then number two, if the worst was to come, then to at least further expose the system. And I think this we achieved because at the end of the day, the judges had the chance to deliver justice, and according to him, they did not. They were biased, they were not independent, they were hell-bent on supporting or letting the other side get off the hook. And according to him, he thought they would have done different this time, and here we are.
What do you make of this, Rwakakamba?
Well, first of all, my friend here, Wameli, is an officer of court. So, accused the courts of all the judicial system of impartiality, I think, has to really be based on really an array.
Is it sentimentalism, or is it actually adducing facts? The fact that in 2001, 06, and 2016, they did allow additional evidence, but this time around they rejected it 3 times.
So for me, really, the issue for me is not. It's okay for Bobby Wine and his team because it is his right to go to court first of all.
Right.
But it is also his right to decide to withdraw from the court process. I think, in my view, that is a fundamental right.
Yes.
Of any Ugandan. But what should be looked at much more closely is what are the reasons, for withdrawing from the court process. One of the things they say is that they have pictured, judges who are involved in this matter visiting State House. But I think an explainer has been issued, by the judiciary. Because remember, we have 3 independent arms of the state: the legislature, the judiciary, and the executive. And for a state to function, these branches of government must collaborate. So if there is a court case, it doesn't mean that the Chief of Justice cannot go to State House to swear in, a judge. And I think that was Margaret Apin. Then secondly, to also attend a function for John and Luwum. So to say because the branches of government are collaborating, that doesn't take away the independence, the independence of each branch, I think, of government. So I find the reasons for withdrawal really not very satisfactory.
But first, interrogate the situation where in 2001, 06, and 2016, additional information was allowed during the hearing of the case to the end.
I think for me, that's the issue. That's a matter of law that should really be interpreted, and I think the justices laid out the reasons why they are not allowing in extra evidence. But mark you, remember recently we had some of the affidavits, it was reported in the papers, that were forged according to a forensic expert. A forensic expert is a professional who looked at some of the affidavits and said that can also be interrogated. It could have been examined on that professionalism. So I think it was a matter of court process. But here is one important thing that I want to say is my belief is that the extremists in NUP, in the opposition, but perhaps also in the NRM and other political parties, seem to be winning. Why do I say that? Because Dr. Chiza Besigye's argument over the years has been that he tested the courts, the substantiality clause, they can't get justice, so the issue is that matters have to be resolved on the streets. And that was the rationale, for walk to work. That was the rationale, for taking, when you hear taking the matters to the people, it's really about taking matters to the streets because, that assumption from, I think, the extremist branch of the opposition that, we cannot trust, that we cannot trust the judiciary. So in my view, I think the best narrative has won over, this argument, from the NUP side. And I think now NUP side is pandering to the best narrative. So it would not be wrong to say that Besigye is back in the game, as the intellectual leader of the opposition forces in the country. And I think NUP might want to really to reflect on that. But I think, in my view, this is Besigye politics. And I think his argument is winning the day. But finally, still on this point, because remember, NUP and some of its most vocal supporters, like Dr. Abed Bwanaka, is the one who he used to participate in elections at the presidential level. And remember in 2006, I believe, or I think, it is when he saw an affidavit in support of, then President-elect Yoweri Museveni, I think
not that, yeah.
That name was not there. In support, Dr. Abed Bwanaka saw an affidavit in support of General Yoweri Museveni, stating very clearly that election was free and fair. I, Abed Bwanaka, I participated in this election, it was free and fair. But he's now, I heard him vocally on a number of radio stations saying that the election is fraud, there can never be justice within this system as long as President Museveni has been president.
But of course, NUP have their own reasons.
So all those issues have to be interrogated.
Anthony Wameli, what criteria did you go through to reach this decision?
First of all, from day one, remember that election petitions were supposed to come in by... That's when the declaration was made.
15 days.
16th, yes, of January. Right away, this particular petitioner was detained in his home for 11 days. So he could not file his petition in time. He was released after the court order was issued. And so he had about 4 or 5 days to prepare the petition. And that's what we were doing throughout the process. And our deadline fell on a Sunday. So we asked the court prior on Friday that we could file on Saturday so that we don't have to hit the Monday deadline according to the law. And the court said, no, you don't have to come. We won't be here waiting for you. You should come on Monday. Monday first, we filed the petition. Saturday next was President Museveni's deadline for his reply. They wrote and said, let's come on Saturday. They said, please come, we'll wait for you the whole day. So you begin to sense that there is impartiality in the process. Then as you move forward, you have gone through so much. Your witnesses are in detention. Your witnesses are being rounded up. Your declaration forms are being taken by police officers, beating up your witnesses. And then you manage to file a petition and you come with affidavits, and then the court says we cannot allow the evidence, yet in denying your amendment to your petition, they said the grounds you want to bring here, you'll bring through the affidavit evidence. So, in fact, Kyagulanyi did not withdraw from the case because the CJ visited the president. No, he has not even raised the issue of that visit or recusal in the court. That was in the press. But as for court, that process is what he is raising, and that bias, that is obvious. And then number two, much as we're officers of the court, but if the client is uncomfortable and he points out the fact that I think this, you see, with bias, you don't have to find the CJ speaking to the president. The circumstances around the conduct of the officers, the conduct of the court, they can create bias, and as long as bias is there, then under the law, someone is free to walk away because they don't believe they will have justice in that process.
Your submission.
No, I think it's a lost opportunity because if you believe you have very strong evidence, you know, even with the perceptions that you may have, I think court provides, you know, a platform. You remember the Rivonia trial, the Mandela trial in South Africa, where even when he believed, rightly so, not like here where it is perceptional, that the system, you know, was unjust to the black people, you know, he entered that system and challenged it, exposed it, appeared before justices that he knew were even biased. Here it is perceptional. But also to remember, in Kenya, for example, nobody believed that Maranga moment, for example, but because the case was so strong, was so undeniable, was so in face of everybody, but Justice Maranga had to go on and, you know.
So it's like you're. First of all, I don't want to lose the viewer. It's like you're saying that NUP withdrew this case simply because they did not have enough evidence, and not because of the partisanship they're saying.
That's really what I believe, because in opposition politics, because remember this was a political matter. In Malawi, even when the opposition was going to court, perceptionally, because of the state capacity and nature of engagement, they believe they are not going to win, but they said, we have the evidence, let's go and present it. And they were surprised by their victory. In Kenya.
Anthony Wameli,
Morrison
Rwakakamba feels like you pulled out because you did not have enough evidence. But what about the 200 affidavits that we saw?
Actually, the reason when he decided finally to
Yes.
because his evidence was not allowed. And you see,
ask him whether there was no any affidavit.
yes.
Because even one affidavit can determine this thing.
Yeah, but you see, you're talking about evidence, and this is the court that is going to tell you that the evidence, there was rigging, but it was not sufficient. So we are talking about sufficiency, we are talking about quantity of the evidence, and the evidence is stuck in the court. And the court is saying, yes, it is here, it was hours late, but we shall not allow it to go onto the record. And yet the client is telling the court what he has gone through, that even up to now, there are affidavits that could still come through when some of these people are dumped by the drones, wherever they will be dumped, or whatever could happen that we manage to bring. You see, at the end of the day, what is the purpose of the court? What is most important? Is it the timelines that you have set, or is it the fact that you determine the matter completely? And my view is that the court would allow this evidence. If it thinks it's not sufficient, then the decision will be rendered. But for you to say you missed your deadline by hours, then you will not allow you. Yet you have 45 days now. Last time you had 30 days. And you also remember that Attorney General failed to amend the law to allow other forms of evidence, like oral evidence, as the Supreme Court had directed, to stick to affidavit evidence. If it was amended, probably it would be easier for someone to walk into court with witness protection and state what they're supposed to state and go away. So the process was so stringent, and yet we did our best to arrive at the doorsteps of court, and court says...
You talk about the arrest and detention of several NUP supporters.
Of course.
Electoral observers.
Beginning with the petitioner himself. Because once you lose 11 days, and by the time you're fighting for your liberty, and then after coming I was surprised that Attorney General was saying no, he was in incarceration, but he should have worked around to find a way of fighting the petition. And he says, no, I was preoccupied with my liberty, securing my liberty. So at this point, I have come. Here I am. We have days we can make ways through until we get to the bottom of this election, and unfortunately we cannot at this point.
Yeah, because I do believe that justices are not from a planet called Mars or Jupiter. They are from here. They live in our circumstances. They follow the events of the day. So if NUP really believed that, you know, their witnesses were tampered with, they were arrested, there are all these injustices, they have now missed the opportunity to be on record. Because once you have the microphone, whereas they say, you know, refer to the affidavit and everything, but once you have the microphone in court, you can be able to put on record, what you believe is compelling. And you would leave it to really the justices, but also the public, this was in public there, to verify whether this has been unjust. And I think NUP has missed that opportunity, but I think they are playing and pandering to the politics, in my view, of extremism, because Kizza Besigye now is the intellectual leader of this, and he believes that not being in court would be to legitimize really the victory of President Museveni, which is already legitimized by the people who voted him anyway. So I think the issue for me is it's a missed opportunity. They have missed a Malanga. They have missed a possible Malanga moment in Kenya. They have missed a possible Marawi moment in Kenya, and they have missed put on record, issues even in
But according to the history we have on ground, they did not miss any opportunity.
No.
They just survived, if you will.
Not at all.
2001, 2006, 2016.
By the way, they did
All
not-
those
no,
moments.
They have even missed, because you see, building a democracy is also about building jurisprudence in terms of remember the Amama Baba's case, how it has even changed the way. Remember, Kizza Besigye, I think, required 5 days, I think, to submit everything. Now, we have 10 days. And remember, the team led by my brother Wameli and Segona, I saw them carrying huge files of affidavits. So it's not even about the quantity, it is the quality. Even if you have 2 affidavits that are pointed, that can really show evidence, I think it can inform justices to make...
So the judges were not scared about the additional evidence that they were willing to bring into court.
Their work very well, with qualitative, not quantitative affidavits, I don't believe they had a chance.
Anthony Wameli and his legal team contend that the justices were actually planning to rule this way, that the evidence adduced in this court was not sufficient enough to warrant a cancellation of the election, just like in 2001, 2006, and 2016. Same judgment. So having this information in court would actually water down their judgment, so that's why they refused. In your opinion, what could have been the reason?
It's just about predetermining the future. And we all know that this judiciary that we always try to hammer, has ruled against the NRM. NRM has lost a lot of cases. Government has lost a lot of money. Many NRM MPs have been thrown out. So there is, and opposition, you ask, for example, Lord Mayor Rwakakamba, even moving this country into multi-party politics was a result of really legislative activism led by Paul Kawanga Semogere, Lord Mayor Rwakakamba, to be able to even arrive where we are. So perfecting a democracy is really work in progress. And I think NUP pandered to the politics of Besigye. Besigye is now the intellectual leader of the opposition once again. They have lost.
All right, Anthony Wameli is the head of the NUP's legal team. Rwakakamba is the executive director, Agency for Transformation. Anthony Wameli, who benefits from this decision to withdraw this case?
My colleague, keeps referring to retired Colonel Kizza Besigye. He's nowhere in this case. He's nowhere. This is his perception is.
NUP has always tried to say Besigye is nowhere.
Wise of him not to go to court because he didn't expect any justice.
No, he's insinuating that we are working according to Besigye's plan, which is not true. This is a case that is isolated. This is a case that Kyagulanyi took to court, and he has chosen to withdraw for the reasons he has explained.
So all benefit.
Well, unfortunately, there's a lot to lose, but there's also a lot to learn. That, for example, if injustice is staring you in the eyes, you have to speak to it and you have to tell it, this is not right. You see, most people fear victimization. Most people think once someone is sitting in that seat of justice, you cannot say anything to them. You have just to bend to the system. But this is the time for us to rise up and say, no, I think if something is not being done the right way, I will not allow the process to continue until the end. I will stop here.
By the FDC themselves, Nanda, he came on boldly and he said, I'm laughing at them for going to court. The former presidential candidate, that is Mr. Patrick Amoria Toboy, also came out and laughed and said, I do not expect anything from that court, but good luck.
Did they expect anything from the election? Probably they did not. Did they expect anything from the Electoral Commission? Probably Patrick did not, but he still participated in the election. But his point was, let me participate up to the point where I can no longer do that. And that's what Kyagulanyi did. He said, let me go. It's one of the reasons. But also, too, to give chance to, you gave Biabakama a chance, he did his role, give to the courts and let them do what they can. For example, I have told you that if the evidence was allowed on the court record, then that would be the beginning point that either we did not prepare in time, it was not sufficient, but for you to look at evidence in the circumstances that were in, even the judges took notice and the Attorney General considered to the detentions, actually by the time we were in court arguing for extension of time, we were in the court martial trying to withdraw or to rather secure release of some of the witnesses and key witnesses, because you're talking about a campaign that took about 3 months or 2 months, but you're also talking about the pre-campaign period. So all that time cannot be in 2 affidavits. You have a lot and you have to traverse the entire country. Some of the witnesses are from outside Uganda, the experts, the statisticians that are going to break down the voter register vis-a-vis the population of Uganda. So you cannot have it in 1 affidavit, and all that is now blocked by the court. Good thing is it is ready for all to see, and probably they will judge whether it was right or not.
Okay, your voters are white now. Anthony Wameli, please be honest. Where there's this NUP voters, I saw some of the clips that were aired yesterday on NTV Tonight, the 7 p.m. and they were not happy. They were like, we do not know his reasons, but we respect what he decided to do. He has his own reasons. So please, what is there in store for this voter? And they are at the losing end.
They are. I don't think they are. He has saved them a lot of time. He has explained to them why he withdrew from the case, and he has told them that as far as we are concerned, the ball is in your hands. It is up to you to judge. It's up to you to look at the situation and see whether I was right to withdraw or not. He actually promises that he's going to relay this evidence to them because it's there. The bundles are there, the affidavits sworn by the witnesses are there, the video clips are there, the audios, the still pictures.
In this case,
you see, at the end of the day, it's about politics. It's about winning the confidence of the people. It's about assuring the people that I did win. He's going to show them polling stations where people polled 100%, and they will see death certificates from those polling stations to confirm that it cannot happen for a polling station to vote 100%, yet about 15 or 20 people died. And so many of those pieces of evidence that they missed seeing in court, they probably will be able to see in the media or in other form of communication.
Aren't you instigating the public to rise up against this?
We are giving them facts and evidence, and it's up to them to deal with it. He has actually emphasized we are non-violent, we are peaceful, we are going to do everything within the law. Even the withdrawal is not an abandonment like probably the 1981 group did. They filed and abandoned, but we are formally withdrawing and even communicating the withdrawal and saying, hey, let's remain peaceful. No bloodshed.
The reason why I asked that question, Anthony Wameli, because according to the latest information, police is actually, the DPP has sanctioned charges of concealment of treason on 8 people, including army personnel. There was a plan, and these people got to know about it, to ban police stations within this country, steal rifles, and attack and topple this government. That's 8 people, including army personnel. The DPP already sanctioned charges of concealment of treason on these individuals, and they could get a conviction of a life sentence. Away from that, Morrison Rwakakamba, does this withdrawal of the election petition by NUP vindicate the NRM?
Well, I think NUP, like it's their right to withdraw. But I think they have missed an opportunity to really prosecute what they call injustice. Okay, they have run away from a platform, where they would have, achieved justice.
I think don't you think they saw a storm and they stopped in their tracks?
I actually believe that, when Chagulanyi gets off the dance floor and gets onto the balcony and looks down the dance floor and he reflects alone, I think he will get very much disappointed, perhaps in his legal team, because Chiza Besigye had 5 days. His legal team had 10 days. They submitted evidence that they now believed was not quantitative enough. Yet what is important is that they needed quality evidence, so qualitative evidence. So
which they decided to bring later on, and it was struck down, yet in previous petitions it was allowed.
If you look at their petition, some people say it was not worth the paper that it was written on. So I think they never burnt enough candles.
Or they were never given enough time.
Not at all. Chiza Besigye had 5 days, okay? And his legal team, led by the likes of Mpanga and the historical Alviris and others, argued a substantive case in court.
But they lost.
And no, it's not about losing. It is about really extrapolating the hand of justice.
I hear you.
And if you look at the jurisprudence in the Besigye cases and Mbabazi cases, you realize that our democracy is getting better. And I'm saying that maybe if NUP team...
How is our
if
democracy
NUP team-
getting better, Morrison Rwakakamba,
this is
if you're
why-
not allowing evidence that you did allow in previous petitions? Isn't that a regression?
No. This is why, you know, I think NUP supporters, like you equally mentioned,
Yes.
are going to be disappointed. Because if the legal team was very well prepared, and they put in the first 10 days qualitative evidence, they could have won this case. We saw it in Malawi, we saw it in Kenya.
But
and
we've never seen it here in Uganda. That's what we are saying, Morrison Rwakakamba.
Because in Kenya it was never there. The way Kenyans believe, they were like, this can never happen in this country. Malawians believe this can never happen in this country. And boo, because they had quite a legal team that presented qualitative evidence.
Of course,
and the judges-
CJ Maraga announced the election for Uhuru Kenyatta. They withdraw security from all these judges to intimidate them.
And they refused. Did you see? But because you see... to
And
try-
later on, CJ Maraga was in bed with Uhuru Kenyatta.
Not at
We
all.
saw that.
No, you
But then back to Uganda here. Don't you think there's a double standard allowing information in previous petitions and disallowing the same within this petition?
Have you looked at the reasons why, for example, it was not allowed? I have just told you that some of the affidavits, according to, you know, forensic experts who are professional, who use science and technology, say they are forged, for example. Have you interrogated that? You see, those are some of the, we need to know what are the reasons, technical reasons. He's a lawyer, he can speak to those.
All right, they had a deadline of 14th February.
Yes,
They went
so-
there on February 15th.
And the law is the law, perhaps. So perhaps we need to investigate. You know, when a law says something, should the judges bend it just because Chaguranya and his team are the one?
Well, they were disallowed
Maybe
to
not necessarily.
file the application on a
What
Saturday.
were the reasons? What were
but for the
reasons-
NRM, they were allowed.
What were the reasons why they allowed evidence before, and why have they refused? it
Anthony
now?
Wameli,
See,
pitching.
Can you interrogate that? Because that's a legal matter.
He's going to answer.
The judge that if the affidavits are forged,
Put them on record. Put them on the test. Let them be received. Because you can only say that they were forged if they've been served on the other party and the other party brings contrary evidence. But that was not allowed, and that's what we are talking about. You see, it is very easy to castigate the team, but he knows that for the first time in a presidential election petition, a party that is sponsoring the petitioner has over 1,000 members in detention in different parts of the country, and arrests are still going, kidnaps actually are going, and the president has confirmed that these people are being picked. And we have told you, maybe Kizza Besigye, and he didn't have 5, he had 10 days, and we actually had 15. Of the 15, 11 were stolen by the Attorney General, the third respondent. So we had 4 days, and all the witnesses, or most of the key witnesses, were in detention, even up to now. That is the situation that we are trying to explain. So if you're talking about evidence or the affidavits, their fault or having no fault, it should be tested when the court allows to receive the evidence. But if the evidence is on the floor, and my cue, when we came on Monday in the morning to file by 7 a.m., the court rejected and had to fix an application for leave 1 week ahead. So we lost another 5 or 6 days that we would have been able to save if the court had received the evidence.
I want to make a quick one. That first of all, nobody should really allow kidnaps, arrests of that nature to happen in this 21st century in this country called Uganda. That's a history all Ugandans, should condemn and should not condone. That's what I have to say. But if there is evidence that that injustice is happening, I thought that would be an opportunity really for NUP to remain in that court and use it to sway the judges and broaden the case, the circumstances, the prevailing and political circumstances that is even hampering their case, because these judges live within the polity of this country called Uganda.
I hear you, Morrison Rwakakamba.
They could prosecute that injustice in the courts and sway the justices.
So there is a viewer who is watching and they are wondering, do you sense that the perceived hostility that was directed at the petitioner, that is Robert Chagulanyi, was it justified, the hostility by court?
It's not absolutely justified, and I think that, now that, NUP was exercising its rights in the correct platform where justice is supposed to be delivered, they could have gone there, in my view, because they have looked at the best prosecutors in the world, the kind of things they do. Yes, you can talk about the affidavits, but their ability to summon the contextual and prevailing environment and appeal to the justices, to their, to their heart of angels, the angelic heart of the justices, they can be able to sway them to make a determination. And that's why I have concerns with the legal team. Not because that I'm, accusing the legal team of anything, but I think, in my view, they never broadened this to specifically summon the context. And if there is evidence of injustice and the kidnaps they are talking about, which is extremely very unfortunate, and which we should condemn, whether you're NRIM or NUP or anybody, they should have used that to really appeal to the justices. And we could have a Maraga moment in Kenya. We could have had a Marawi moment in Kenya. And I think the lawyers of NUP, in my view, took away that opportunity from the supporters.
Well, Morrison Rwakakamba, history proves otherwise. But Anthony Wameli, let's give you the last nod to speak to the country. You have until Wednesday, yes, to formally tell the Supreme Court that you're withdrawing your case. Let us in on the modalities before we go. What next?
The injustices are stuck in affidavits. Actually, most of the affidavits that were rejected are from the people who were arrested in Kalangala. If you have a chance to look at those, that's how you can tell court. You can, Segona or Wameli cannot stand before the justices and start explaining what happened when they were dumped on those armored trucks and taken to Kalangala. The best way was to have those affidavits in. But now you...
Mandela did it in South Africa.
So, but as far as NUP or Chagulanyi is concerned, we are formally filing an application probably today afternoon to, it has to be with leave of court. Much as you withdraw, but we file the application, it's fixed, and the other parties had, then the justices will make a decision. But I don't see another decision apart from the fact that they will let you leave the court, and probably they will condemn you to costs, which will be taxed, and then we'll call it a day.
Okay, the legal director of the NRM legal, that is the director NRM legal team, Oscar Kihika. He did say that you will incur most of the costs when it comes to the withdrawing of this case. And we would also like to know from you, does the withdrawal of the case actually justify what FDC was saying, that it was bound to fail?
No, it doesn't.
I think we have not failed. I think we have achieved what we had to achieve in the circumstances. And about costs, I think Chagulanyi is not scared, because he told you yesterday that he has lost much more. People have been buried during this campaign. Senator Frank was killed in the process of campaigning. So for you to talk about money or costs when we are talking about a democracy, when you're talking about building constitutionalism and rule of law, I think that's not an issue for discussion. Exactly.
Exactly. Thank you very much. Anthony Wameli, the head of NUP's legal team. He was not alone. I also did have Morrison Rwakakamba. Like I always say, I do enjoy such scenes of dialogue without exchanging any fist fights. Thank you, gentlemen.
Thank you for having me.
Thank you for coming. All right, that's it for this show. My name is Romeo Busiku. Of course, we shall be here tomorrow, same time, with a lot of information for you, especially right here on Morning at NTV. Good morning and good day.